Welcome back to Rico Busters, and again to yet another revealing story of corruption, malicious prosecution, and racketeering by those wishing to claim positions of status, being that of our illustrious government. As with many of the previous stories presented by Rico Busters, this story arises in the corrupt state of Michigan. In the upscale city of Novi, a lively population that the highly acclaimed Oakland County boasts as being one of the top wealthiest counties in all the United States. This is the county that supposedly has residents making the Forbes 400 list, where some of the nation's most prosperous people live. Here's Novi with a median household income of nearly $83,000, where 55% of adults have college degrees. But it might as well be a city or township in any community of the United States because apparently the 52nd District Court of Novi, an integral part of the corporate state of Michigan's corrupt judicial system, thinks all people should be treated like they are complete idiots. Now bear in mind that this news story follows a similar history of corruption coming out of the Novi Police Department, which shares the same block of real estate with Novi City Hall, and yet other stories of corruption coming out of the 52nd District Court, which is located at 48150 Grand River, where Novi meets the neighboring town of Wixom. Notably, two previous judges of that 52nd District Court have lost their jobs due to corruption in office, and the Novi Police Department was successfully sued by one of their own as a whistleblower when he sung like a canary about mandated police quotas on ticket writing while reasoning that it was to generate income for the city of Novi, which not so incidentally is still the so-called plaintiff in numerous ticket cases that continue to go before 52nd District Court judges and magistrates.
Good evening. That tops our news at 6. We've all wondered if there was another reason for that ticket that we received.
Everybody has suspected this for years. According to one officer, there is such a thing as a quota for writing tickets. In fact, he says when he spoke up, he lost his job over it.
Well, now he has settled a lawsuit with his former department, and he's revealing what's going on. Priya Bad joins us now live in Novi, and it is important to note quotas are illegal.
Absolutely. Good evening, Steve and Karen. Right off the bat, in 2010, the Michigan legislature prohibited using the number of citations a police officer issues as a factor in their performance evaluation. But this document proves traffic ticket quotas are very much real. Not only is each officer being cataloged for the number of tickets they are issued year after year, they're being compared with the expectation they will continue to issue more tickets.
I never would have guessed that the early part of my career would have been the most moral and the best.
Michael Corbett was a Novi patrol officer for close to 25 years without a single write-up. But it was pressure to write traffic tickets that he says turned the law enforcement agency into a revenue collector.
Work was all about. And it became very clear that there was more to it than that. There was a business side to it.
Corbett says the orders came right from the top. In 2009, officers were told it was mandatory to make 4 stops a day and issue 2 tickets. A year and a half later, officers were told to include commercial vehicles, which generates on average $1,000 in violations, and make more arrests, which can rack up hefty court fines. Here's the thing. Traffic tickets are raising on average between $40,000 to $50,000 for the city every month.
This particular Rico Buster story started with just such a citation, one similar to that referenced by the mainstream media's news story 3 years ago in 2014, being one issued by fraud so as to generate income for both the city of Novi and the state of Michigan. Until now, however, the mainstream media has grossly neglected to address how such criminal fraud associated with the writing of bogus tickets becomes a racketeering scheme of securities and insurance fraud, operated by a wider crime syndicate consisting of State Bar of Michigan members, of magistrates, judges, prosecuting attorneys, and private attorneys, court clerks, and even those under employ at the Michigan Secretary of State, who for the past several years also goes by the name of Ruth Johnson. So you may ask, how does the proverbial mountain of a sophisticated racketeering operation come out of the proverbial molehill of a simple ticket written by a single police officer? I thought you, the viewing audience, would never ask. Let's consider that upon a so-called finding of guilt or responsibility, as they like to say here in Michigan, not only is a fine apparently assessed against the person, but so too are insurance points. Each of these devices causes numerous people to be labeled as offender, i.e., defendants, by corrupt police officers and magistrates as the court officers, and to thereafter be monetized by these officers fraudulently corralling these people into the commercial marketplace through securitization and bonding. From here on out, I will refer to those labeled as defendants by these corrupt officials as crime victims of such a criminal racketeering setup. More recently, I have discovered that if the crime victim of a bogus ticket and court ruling of responsibility chooses to challenge or appeal the so-called determination of a magistrate or judge, such an appeal is held hostage by the clerk of the court under a supposed statutory demand that the full amount of the ticket first be tendered to the clerk as a commercial bond payment. This constitutes felony securities fraud by those orchestrating this setup, particularly in situations such as this, wherein there was no disclosure of the bonding condition at the onset of what was supposed to be an informal hearing, in which the magistrate had asserted that both parties have a right to an appeal of his decision. This is important because had such a disclosure been made at the onset of that informal hearing, that there was a formal decision to be made tied to commerce, any prudent defendant would insist upon a judge rather than a mere magistrate, and would focus upon cross-examination of the so-called plaintiff and witnesses rather than take the chance of self-incrimination as a witness against oneself. But here we have a situation where the magistrate used trickery and gross omissions when setting forth its fact that the hearing was informal, and grossly omitting the formality of his ending decision that would bind the defendant in commerce to that ruling, and under threat that if the formal judgment of fine or the bond on appeal was not paid, that the marked offender would subsequently be prone to also losing his so-called state privilege to drive. This is especially criminal given that the defendant in this case never admitted to be operating a privilege in the first place, but was instead operating upon his federally guaranteed right to travel. It appears that part of the modus operandi of these judicial criminals is to take the posture and the assumption that all defendants are operating on a licensed commercial privilege to drive rather than a constitutionally guaranteed right to travel freely wherever one wishes within the continental United States. So as this story reveals, the criminal racketeers who are otherwise usurping positions of legitimate government consist minimally of the officer writing the ticket, the magistrate determining the case, and the clerk taking in the money. When this type of thing occurs with regularity, such as in the matter of pattern and practice of quotas or other criminal devices involving the types of deceptive practices that were implemented in this case, those participating in such schemes are plainly guilty of running financial crimes organizations, which are federal crimes under, again, minimally, Title 18 U.S.C. or United States Code, Section 225. So here's how the racketeering scheme works and how mountains are made from molehills. When fraudulent incident reports written by police officers and fraudulent points are reported to insurance companies by court personnel along with the fraudulent determinations of responsibility by corrupt judges and magistrates, commerce is again involved. Not only do corporate insurance companies refer to and depend upon those fraudulent incident reports for determining which insurance company holds financial liability if there are any damages to people and property caused by the so-called incident, but so too those points are tacked on as further punishment against the person that was fraudulently determined to be at fault and responsible for the incident, which leads to higher premium costs not only for the victim of such racketeering schemes, but so too for every person subject to the ever-escalating cost of insurance premiums in general. This is because that same fraudulent information contained in the police incident report and the magistrate's determination of financial responsibility is statistically included in reports from the insurance companies to the state insurance commissioner, which is subsequently relayed to state legislators and thereafter used by those legislators to determine the degree to which their insurance laws are or are not being effectively applied and producing the intended results. When the domino effect of the fraud reaches the legislators, it affects every living person subject to their laws. In other words, when police officers' reports to insurance companies are based upon fraudulent facts, and judicial determinations of financial responsibility of insurance providers are based upon fraudulent proceedings conducted by corrupt judges and magistrates, the entire insurance industry, the entire body of laws of the state, and the masses of people inhabiting the state subject to those laws are negatively and financially affected. There is no doubt that such fraud constitutes a multitude of crimes involving, minimally, the securities and insurance industries. Most members of these securities and insurance industries are large corporations doing business nationwide in the stock market, using those fraudulently issued bonds and those fraudulently impacted national and international publicly owned insurance carriers. That is why I have written to these people, these local, state, and federal government officials, in report of these multi-tiered criminal matters. But first, allow me to introduce the smoking gun revealing fraud at the base level by those I refer to as domestic terrorists operating in my hometown of Novi, Michigan, to turn the due process into racketeering schemes for profit. Let's start with the City of Novi police officer Timothy Shea, who initially wrote what he ended up identifying at the informal hearing as an all-encompassing ticket. Were you aware that the City of Novi has police that write all-encompassing tickets? Whoever thought that one up? And the magistrates of the 52nd District Court here in Novi, Michigan can even keep a straight face while endorsing such a claim for the city in commerce. So the first smoking gun is this all-encompassing ticket that police officer Timothy Shea was citing against me on behalf of the City of Novi and using the uniform laws and the so-called judicial courts of the state of Michigan, which was for the civil infraction specified on this ticket as Michigan Compiled Law 259.649, which the officer had construed as a failure to yield the right-of-way to oncoming traffic, being the failure to yield to a vehicle on the right and at a stop sign. Yet pictures that I took of the scene show that there was no stop sign at the location where the incident occurred, in which I was struck from the backside by another automobile. Here are a few angles of the location on the road where I was hit from behind, and it is clear to see that there is no stop sign at that location. Moreover, when I went to the Michigan Compiled Laws and looked up MCL 259.649, what I found was that everything referenced by that so-called civil ordinance was related to clearly marked intersections, intersecting roadways, merging highways and streets, and highways. So again, my pictures of the location where I was hit from behind show clearly that there was no intersection at the actual scene of the so-called incident, but instead one further up the road. Notably, at the informal hearing where the Novi officer Timothy Shea declared this to be an all-encompassing ticket, however, the 52nd District Court Magistrate Victor Zanoli III agreed with the officer to use this all-encompassing ticket to hold me responsible for something written down that is actually non-existent. I call this railroading. So here's the second smoking gun. I have pictures of my pickup truck showing where my automobile was struck at the rear, and then I showed those pictures to the officer Timothy Shea and to the magistrate Victor Zanoli III at the so-called informal hearing. Meanwhile, the commercial driver of the other car claiming to have hit me, as well as the Novi police officer Shea, both claimed that I was broadsided. At the so-called informal hearing, the commercial driver repeatedly insisted that he had hit my pickup in the rear driver's side door, despite that I repeatedly offered my pictures as proof that I was hit at the rear of my vehicle. I also insisted at that hearing, which was held on June 26, 2017, that anyone questioning my claim at that informal hearing might simply walk outside of the 52nd District Court building to see that I not only had a two-door pickup, but that the only evident damage to it was at the rear and not at the side. Incredulously, the magistrate just gave me a blank stare when I made that offer. How simple it would have been, given that this was supposed to be all informal, to just go outside and look at the frickin' pickup itself. Yet, despite that neither that commercial driver nor the police officer Shea brought in a lick of evidence to support their sworn beforehand as truth testimonies, the magistrate chose to deliberately mishandle this matter at the informal hearing by concluding that I was responsible for paying the fine on what they together concluded was an all-encompassing ticket of a failure to yield to oncoming traffic from the right at a stop sign. Needless to say, what happened at the 52nd District Court in Novi on June 26, 2017 constituted criminal perjury and the falsification of official evidence by Timothy Shea, and the criminal deprivation of my due process rights by the so-called magistrate Victor Zanoli III by his executing a sham informal hearing as a kangaroo proceeding. Perhaps at this point in this documentary, we should look closer at who this so-called magistrate, Victor Zanoli, really is, and what he is really doing by looking at the bigger picture of things in their proper context. As previously stated, there is a world of difference, judicially, between being a judge and being a magistrate. As shown, corrupt magistrates are appointed by their State Bar of Michigan peer group of corrupt judges. Zanoli was thus appointed. Let's see why they might have chosen Zanoli. Well, first and foremost, it's because he is a fully vetted, card-carrying member of the State Bar of Michigan. Secondly, it's clear that he is willing to break the ethics of his profession to engage in matters of a conflict of interest. Let's see. It shows here that one of the key issues for judges is for them not to allow their community activities to leave the public with the appearance that they are using their judicial office to benefit private organizations, as I am to be proving that Zanoli is using his judicial office to allow his host of quasi-government municipal corporations to profit by his participation in their own widespread organized crime syndicate involving the city of Novi, the Novi Police Department, the 52nd District Court, the Judicial System Fund, and the Michigan Health and Human Services under the direction of Nick Lyon, who was just recently indicted by the Michigan Attorney General for involuntary manslaughter, along with 4 or 5 others of the Rick Snyder administration, in connection with the Flint water deaths and surrounding finger-pointing debacle. Folks, this is not government. The fact is that these are all subsidiary shell companies of large franchise organizations operating in commerce. This has been known since World War II, as determined by the United States Supreme Court in the case of Clearfield Trust Company versus the United States. which stated that when private commercial paper is used by corporate governments, then those governments lose their sovereignty status and becomes no different than mere private corporations. As such, government corporations are bound by the rules and laws that govern private corporations, which means that if they intend to compel an individual to some specific performance, like subjugating themselves to a privilege to drive, as opposed to holding the inalienable and unalienable right to travel, so as to subjugate us to their own corporate statutes, ordinances, or rules, then the government, like any other private corporation, must be the holder in due course of a contract or other commercial agreement between it and the one upon whose demands for specific performances are made. What's going on here, people, is the state of Michigan is stealing our federally guaranteed rights to travel and selling those rights back to us as driving privileges for a fee, while using our application for driver's license as just such a contract to subjugate each and every one of us to treatment such as what I am describing to you in this video as domestic terrorist occurrences. They want to call what has occurred by the writing of a uniform law citation an incident, while I call the bigger picture of what is going on here a criminal racketeering scheme that rivals the level of criminal injustices and cover-up of those injustices right here in Michigan, victimizing scores of thousands of people living in Flint and only now revealing itself as felony crimes being committed by other domestic terrorists operating from the highest offices of the so-called Michigan government. It's easy to get off track in presenting the bigger picture here. Where I got distracted was at the point of revealing that even though this 52nd District Court's supposed magistrate, Victor Zanoli, is supposed to be held to certain standards of ethics in his professional practice, as persistently practicing as an attorney, as the co-owner of his own law firm, and as an appointed magistrate for the 52nd District Court, this State Bar of Michigan member Zanoli is operating in blatant violation of both judicial ethics and judicial orders coming straight out of his own 52nd District Court. I mean 52nd District Court Corporation. See, here is Administrative Order number 96-019, which specifically prohibits that practice of law at the 52nd District Court by any magistrate like Victor Zanoli III, which I found just recently still posted at the Oakland County government website. Notably, this prohibition was issued by the Michigan Supreme Court. And again, I wish to remind the viewers that this is the same Michigan Supreme Court wherein former Justice Elizabeth Weaver served before writing her whistleblower insider book about the corruption at the very top of the state judiciary system. This is the very same system that is shown to be financially benefiting from the revenues collected locally from police tickets. So you may ask, where's the smoking gun showing that Zanoli is violating this administrative order and is still practicing law in Novi? Again, I thought you'd never ask. It's here. Take a look as I pulled this information off of lawyer.com and Zanoli's own website the very same day that I found the administrative order posted at the Oakland County, Michigan website. This business listing clearly shows that even though Zanoli apparently became a magistrate in 2015, Zanoli has been practicing law until today all over southeast Michigan, including the city of Novi, where he proudly represents his clients. It also shows him to be a specialist in litigating traffic violation cases. So might this be reasonable evidence that Zanoli is engaging in ethics violations by at least the appearance of operating with a conflict of interest? Please, allow me to continue. This is just the beginning of my criminal allegations against this judicial impostor and usurper of the people's power and authority. That's you and me, folks. Getting back to my criminal complaint. Needless to say, my criminal allegations are much more serious than the mere civil infractions that these corrupt police and judicial racketeers used in the attempt to ensnare me into their jurisdictional trap, with both the civil and the criminal actions being statutorily linked directly to commerce. That is why I distributed this criminal complaint, which was written in the form of a constitutional citation against all those associated with putting together and sanctioning of this railroaded racketeering scheme, being minimally the city of Novi and their police department writing this so-called all-encompassing ticket, being the 52nd District Court and their clerk, being the state of Michigan, and being the State Bar of Michigan that has obviously trained, qualified, and licensed this judicial imposter. These are all of the relevant constitutional violations that I see were involved in this widespread crime syndicate and criminal racketeering scheme to frame me and then steal the hard-earned fruits of my labor while committing securities and insurance fraud. In getting back to the evidence presented at the informal hearing presided over by Zanoli, I had identified the person claiming to have broadsided me in the rear driver's side door. I identified him earlier in this narrative documentary as a commercial driver. Here's a picture that I took of his chauffeur's driver's license at the scene of the so-called incident before Novi police officer Timothy Shea arrived. Here are other pictures that I took at the scene too, which shows the car chauffeur Passmore was driving, and the damage that he was claiming at the informal hearing was the result of his hitting my pickup broadside. Note that his car was a 2001 Nissan Sentra with a license plate number of DPF 6436. Which appears to correspond to the information on Passmore's proof of insurance card that he also handed to me at the scene of the incident. Okay, so here's one of the most obvious smoking guns of this case. This is Novi, Michigan Officer Timothy Shea's so-called incident report that goes to the insurance companies to formally advise them of the facts about the automobile accident. This incident report shows that Passmore was instead driving a 1998 Mercury Sable when he hit my red truck broadside, which in any regard is a proven lie committed by both the police officer and this commercial chauffeur Elijah Passmore. Yet again, the crooked 52nd District Court official, i.e. the State Bar of Michigan member authorized by the crooked Michigan Supreme Court to be committing securities fraud and other crimes of conspiracy openly inside a public building, the so-called magistrate, Victor Zanoli III, used those unsupported bare assertions as the basis for throwing out all of my evidence and statements so as to railroad that informal proceeding into a formalized judgment and cash cow for the city of Novi, for the 52nd District Court, for the retirement fund of judges, for the state of Michigan, and who knows who else is involved in these corrupt corporate organized crimes and layered racketeering schemes. By the way, during that informal hearing, I called special attention to the fact that Officer Timothy Shea had, for some unexplained reason, grossly omitted from his incident report Passmore's chauffeur status as a commercial driver licensed by the state of Michigan. Both Shea and the magistrate, Victor Zanoli, conspired together to fraudulently claim before a courtroom full of witnesses that the omissions of Passmore's chauffeur status were done by the Novi Police Department clerk as a matter of legal procedure and as a result of legislation to protect the personal information of Passmore. So why did they do this? Both the officer and the magistrate teamed up against me to assert that this is the law, when I otherwise have found my own evidence that their assertions to me, issued while the officer was under a sworn oath to tell the truth, and the magistrate was under a supposed oath of office to the state and the federal constitutions, were nothing but a crock of bullshit. Driver's license numbers issued by the Secretary of State are neither personal information nor information exempted from Freedom of Information Act laws mandating transparency in government. But both this so-called magistrate, Zanoli, and this so-called police officer, Shea, would have the courtroom of other people who were there for similar informal hearings believe that we, the people, are not entitled to this sort of information from our so-called government. Again, I ask, why would they do this? The specific details of what went on at the informal hearing before witnesses at the 52nd District Court are all written down in the form of a sworn and notarized affidavit. In common law and in commerce, signed sworn written testimonials present legal truth, particularly when supported by evidence. This is truth that stands strong enough to convict the accused of the crimes they are alleged to have committed, unless and until countermanding statements of opposing truth and evidence are introduced. This imposes the duty of every one of those so-called government agents to take proper criminal action upon my similarly sworn and notarized criminal complaint, which again were furnished to all of these people in both state and federal offices, being Daniel Lemish, who President Trump appointed as the new United States Attorney for the Eastern District of Michigan, taking the place of the Obama appointee of Barbara McQuade, who I repeatedly presented reports of other crimes. Over the years, I accumulated enough evidence to back my accusation that McQuade, like the current and former Michigan Attorney General Bill Schuette and Mike Cox, had been harboring and providing safe haven to many others of their peer group of domestic terrorists, who have been acting not unlike Officer Timothy Shea and Magistrate Victor Zanoli III in this case. So here is Jeff Sessions, the new United States Attorney General appointed by Donald Trump, taking the place of Obama appointees Eric Holder and Loretta Lynch, who I have proven sold out America long ago. Sessions was the second of 8 total people to receive my sworn and notarized criminal complaint against Zanoli and Shea et al. For larceny, malicious prosecution, misleading filing to obtain a securities instrument, fraudulent misrepresentation, counterfeiting a public record to procure a financial instrument, fraudulent insurance acts, unfair conduct in commerce, and conversion of rights to privileges by denial of due process and a jury trial. U.S. Marshal Robert Grubbs, who is stationed in the Eastern District of Michigan and working closely with Lemish, was the third to receive my package of criminal complaints and supporting ledger containing my lawful claims of damages in commerce. This completes the list of federal law enforcement I am holding accountable for providing me with relief and remedy to these thus far unrebutted and technically irrefutable criminal claims. At the state level, I have presented these sworn criminal allegations to Michigan's chief law enforcement officer, Bill Schuette, against whom I have accumulated mounds of evidence, like with Schuette's cohort, the former U.S. Attorney Barbara McQuade, and Schuette's predecessor Mike Cox, that all of these government usurpers have been harboring and providing safe haven to a statewide crime syndicate fraudulently posturing as legitimate government. Additionally, on July 12, 2017, I also sent my crime report and ledger of damages in commerce to the Director of the Michigan Department of Insurance and Financial Services, Patrick McFarland, to the Michigan Secretary of State, Ruth Johnson, to the Corporation Securities and Commercial Licensing Bureau Director, Julie Dale, and to my state representative, Kathy Crawford, representing the city of Novi. Isn't it any wonder that despite my having proof of delivery signatures showing the receipt of my criminal complaints by all of these addressees, and despite that I have given them 7 days to provide me with any form of response, that we are now 3 weeks later on August 4th, and none of these so-called public officials have extended an effort to assist me with doing something about these reports of criminal wrongdoing? Again, isn't it a wonder? Notably, these past 3 weeks that I have been giving the opportunity for the above-listed people to respond, I also took it upon myself to investigate these crimes by using laws designed to address the constitutional requirement for transparency in government. Would you believe that I have run into the same type of bureaucratic and criminal stonewalling by county and state government officials in response to Freedom of Information requests for documents? This is stonewalling rivaling that which is currently being prosecuted, only too late, by the Michigan Attorney General resulting from the Flint water crisis. Notably, who I am dealing with now is the same corporate state of Michigan that is responsible for the many deaths associated with that Flint water debacle. While I do not expect government agents to readily confess to the commission of their respective crimes, or to voluntarily arrest and prosecute those of their own peer group of fellow criminals, I do hold the government's feet to the fire when it comes to properly answering FOIA requests for documents under the laws compelling government transparency. So now I am going to show you just some of the many unlawful tactics that government agents use to shirk these FOIA or transparency laws, besides doing like Jeff Sessions and the rest of this group who are altogether ignoring my correspondence, as demonstrated by these government usurpers' refusal to respond to my criminal complaints and ledger for damages in commerce. There were 4 separate Freedom of Information Act requests for information that I sent out, and it is important for the public to know both why I sent out these requests and the manner in which this so-called government responded, or failed to respond appropriately, to each. The first 2 requests were sent to the Michigan Secretary of State's Office of the Great Seal and to the Michigan State Court Administrator Milton Mack. The basis for these 2 FOIA requests rests with that 2015 administrative order appointing Victor Zanoli to the position of magistrate, in which Zanoli's qualifications were listed at the top of the page 2 of that order. I was seeking to verify and validate what I saw were 2 of the more important of those qualifications, being that Zanoli had subscribed to an oath of office in allegiance to the constitutions of the state and the United States, and that he had completed a training course given by the state court administrator's office. I was also requesting the same information regarding another so-called magistrate that I knew was operating in the 52nd District Court, a man by the name of Michael Bosnick, who I have criminally associated with other known domestic terrorists operating similar crime syndicates out of the 17th District Court in Redford Township, a suburb of Detroit in the neighboring Wayne County of Michigan. Interestingly, I have record also that the latest in a line of criminals operating out of the office of Michigan State Court Administrator Milton Mack has numerous outstanding criminal allegations against him as the former long-standing probate court judge of Wayne County before moving into his new administrative position, being in charge of how all the courts in Michigan are being supervised and orchestrated. The reason why I was seeking the judicial oath of office from the Secretary of State's Office of the Great Seal is because this is where I know all of the judges' oaths of office are supposed to be found or officially verified as non-existent, costing only $1 apiece upon written request. Apparently, the Office of the Great Seal does not mess around with oath of office of magistrates, however. Here is the response that I got back from the Secretary of State in Lansing, suggesting that I instead go to the Oakland County Clerk's office where those records may be filed and maintained. I'll show you what happened to my initial Freedom of Information Act request to the Oakland County Clerk's office in a moment. I want to first show you the response that I got back from Milton Mack's State Court Administrator's office. Someone named Dawn Monk, operating on Mack's behalf as the Chief Operating Officer, wrote only 2 sentences in response to my FOIA request. She stated simply that the judiciary, which includes the State Court Administrator's office, is not subject to the Freedom of Information Act. For clear reasons related to the intent to block transparency in government, the highest administrative office of the state judiciary purposely refused to verify that Victor Zanoli had actually completed the training course in traffic law adjudication and sanctions that was supposed to have been given by that very office. Further, This Don Monk also refused to provide me with an alternative way that we, the people, might otherwise obtain this very important information related to a public administrative order of 2015, which, upon closer inspection, appears to be predated by this corrupt judge to be January 3rd, 2018. Note that though the signature is above the words Chief Judge, there is no positive identity on this name, which cannot be read and which fails to match the names of the two judges of the 52nd District Court at the top of this administrative order. So is this an invalid order and Zanoli actually does not have to complete the training course? Is this what Mac's office is trying to cover up? So what the fuck is going on here? Is it no wonder that Michigan's government was rated dead last all the way at the bottom, 50 out of 50, in transparency by the Center for Public Integrity when issuing the results of their 2015 state study, rating the Michigan judiciary with an F for judicial accountability? Here's the third Freedom of Information Act request. The one that went to the Oakland County Treasurer, Andy Meisner, dated July 17, 2017, in request of all information related to the $50,000 performance bond of Victor Zanoli and his compadre, Michael Bosnick, at the 52nd District Court in Novi. Note that my letter specifically states that I wanted to receive the requested information back through the mail, and that my email address was to be used only in the event that the requested information ends up being extensive, and that in such case it was to be used to open a two-way dialogue of communication to discuss that matter. Perhaps by now you, the audience, might not be surprised by the manner in which the Oakland County Treasurer is avoiding this simple obligation of just mailing me the requested information, or to contact me in some personal matter to discuss my receiving this information by means other than through the standard mailing of FOIA responses. The first communication sent to me in response to my FOIA request to the Oakland County Treasurer was a fraudulent notice sent to my email thanking me for having registered with the Oakland County Records Center. It also indicated that I had somehow initiated some other communications medium involving a password. Note that this notice came to me as some type of automated response that did not even allow two-way correspondence, which I had initiated by my personal notice to Andy Meisner of being the only condition upon which my email would be allowed to be used. Even though I had recognized this correspondence to be set up in an autocratic or dictatorial fashion, as a one-way communication from them to me using an email address that I had provided under strict terms of otherwise being two-way correspondence, I responded right away with a cease and desist order using the same medium that they used to contact me. I also communicated my assertion that their allegation that I had knowingly and intentionally registered for anything constituted fraud, and that that assertion, as conveyed through the internet, constituted wire fraud. I also sent this notice of felony wire fraud to the same state representative, Kathy Crawford, that was refusing to respond to my criminal allegations about Zanoli and Shea. Notably, Kathy Crawford has never responded to this either. That same day, the Oakland County Records Center, acting on behalf of Andy Meisner, sent me yet another one-way message in the form of wire fraud. This one was sent to acknowledge the content of my Freedom of Information Act request, but references an attachment that does not and never did exist. Folks, can you see how this corporate entity of the Oakland County Records Center and the office of the Oakland County Treasurer, Andy Meisner, behind all of this, is falsifying that which is non-existent, which you and I both know will be printed out and used later by crooked State Bar of Michigan attorneys as evidence to be used against me in civil proceedings should I set out to sue Oakland County for their refusal to properly provide me with copies of performance bonds that I had asked for under legislation of the Freedom of Information Act? Note that this no-reply email presents me with completely irrelevant information that admittedly has nothing to do with the Freedom of Information Act. They might as well have written that the Freedom of Information Act does not require them to send people to the moon or to clean toilets. The fact is that I've never said that it did require them to do anything other than to send me what I demanded, by mail, unless otherwise negotiated in a two-way communication. Note that I have read the Freedom of Information Act, and it does not require them to set up such one-way communications and to commit felony wire fraud as seen here either. Here's a response back sent to me by the Records Center showing that this corporate entity did indeed receive my cease and desist notice and accusations about wire fraud having been committed by them, with no comments. The audience should note, as I did, that the Oakland County Records Center seeks to inform me about what the Freedom of Information Act does not require them to do. Well, let me just say that FOIA legislation does not provide them with the means for them to dictate to me that I must do anything either, since I have already invoked the power of the people by referring to the legislation of the Freedom of Information Act when compelling them to fulfill my demand for evidence of documents. It should be clear by now that this is how the Charter Corporation of Oakland County and its agent Andy Meisner are both using administrative policy and procedure to undermine the spirit of the law in constructively denying me documents, while setting up the means by which a half-witted and crooked State Bar of Michigan attorney and Michigan State judicial usurper can together claim that it is my fault for not actually receiving this requested information that otherwise was never sent back to my mailbox by the Oakland County Clerk, Andy Meisner, as I had initially demanded and never refrained from demanding throughout this entire railroading by the domestic terrorist operating corporately as Oakland County. So let's now turn to the constructive tactics used by the City of Novi's Police Department and its agent, Sergeant Kevin Ray, using the thin blue line to cover up for his fellow police officer Timothy Shea's fraudulent statements, which was fraudulently concurred by the so-called magistrate Victor Zanoli, when stating that the Freedom of Information Act authorized the redaction of commercial driver's license numbers from incident reports, and by the associated claim that commercial driver's license numbers issued by the state of Michigan somehow contain identifying personal information. Importantly, my FOIA request to the Novi Police Department also included the request for documents that show what policies the Novi Police Department uses for executing such redactions, such as by blackout, by whiteout, or other method of digital redaction provided by computer software. Here is the FOIA answer by Sergeant Kevin Ray, who is in charge of training and standards at the Novi Police Department, who is Timothy Shea's criminal compadre that responded to my FOIA request to the Novi Police Department. This is how he constructively denied me the information without actually stating such a denial, but instead by sending me other extraneous information that was not directly related to my specific FOIA request. Check it out. As I suspected, the audio and video footage evidence to support my contentions were destroyed prior to Timothy Shea even arriving to the informal hearing and committing criminal perjury by lying under oath numerous times. As I have seen to be the pattern and practice of most all other agencies of the so-called government in response to FOIA requests for information, this Novi police sergeant used the phrase "to the extent that your request seeks documents pertaining to," and couched the rest of the sentence in some statement so to whitewash over the specific document or documents I had originally requested. This was done by Sergeant Ray so as to allow him to substitute other documents for those I had otherwise specifically requested. This fraudulent tactic was used so as to either replace one document for the other I had originally requested, or to cover for the fact that such a document as I had specifically requested does not actually exist. In this case, I believe it was done for both reasons. See, I was looking for the existence of any document to support Shay's and Zanoli's joint claim at the informal hearing that the redaction of a commercial driver's license number assigned and maintained by the state of Michigan was necessary because it somehow constituted personal information subject to redaction under the law. At that informal hearing, Officer Shay pro-offered an associated fraudulent claim that such redactions are carried out by the Novi Police Department clerk by some whiteout method rather than by a blackout method. What Ray sent me instead was the generalized line of the Freedom of Information Act authorizing the general redaction of personal information. Ray's response, therefore, essentially constituted a waste of taxpayer money to provide me with nothing specifically requested, but instead sending me a reiteration of something which I had referred to myself in presenting my original request for proof that commercial driver's license constituted personal information in the first place. Importantly, I found this court case citation embedded within the body of this otherwise worthless pile of documentation sent to me as a replacement for the specific documentation that I had requested. It is embedded in the Directive 530 issued to Novi Police Department personnel by the Chief of Police, David Malloy, as dated March 3, 2015. It says, quote, "All public records are subject to full disclosure under the Freedom of Information Act unless the material is specifically exempted, and the exemptions to disclosure are to be narrowly construed because FOIA is intended primarily as a full disclosure statute." Unquote. Further down on that same page, this Directive 530 goes on to describe specifically which documents qualify for exemption to disclosure. Note that I have carefully scrutinized all of these entries, which I have pictured here, and none of those exemptions even come close to stating that commercial driver's license numbers assigned by the state constitute personal information, or that commercial driver's license numbers are to be exempted from disclosure to the public under FOIA laws. So by using the phrase, "to the extent that your request seeks," and then putting his own line of categorical bullshit in place of my specific request, the so-called Sergeant, Kevin Ray, can get away with neither granting nor denying my request for documents, when in fact, my specific request should have been categorically denied, as were my requests for audio and video footage were denied because these documents exempting commercial driver's license numbers from FOIA answers are non-existent. I reasoned this for a couple of reasons. First, because I have many times already seen just the opposite tactic used against me by other so-called government agencies that outright denied me information by their claim that I have not been specific enough about what I am requesting in documents. The Michigan Attorney Generals Mike Cox and Bill Schuette have used this methodology to deny me transparency in their racketeering crime syndicates, which they call government. Another method these two shysters are known to use is to write back FOIA response letters to me claiming that they have simply mounds of answering documents and to charge me upward of $8,000 to fulfill my document request, while directing me to pay half of the total amount, being more than $4,000, up front and before they would ever consider fulfilling my order under the transparency laws. So this is how they do it, folks. As I now conclude this 21st Rico Busters documentary about corruption, racketeering, and domestic terrorism, I must inform you, the viewing audience, of the following. That as the first of two 52nd District Courts is doing what you have been informed is being done to me, simply because I have an operator's driver's license, the second of two 52nd District Courts has been criminalizing the liberties of another patriotic-minded American simply because he has chosen not to subject himself to those domestic terrorists. What I mean to say is that after the so-called magistrate, Victor Zanoli, saw me completely discredit the so-called testimonies of the City of Novi police officer Timothy Shea and Elijah Passmore as the so-called witnesses to the plaintiff being the City of Novi, even though Zanoli opened the so-called informal hearing by identifying Shea and Passmore as being the so-called plaintiffs. At the end of the mockery that Shea and Passmore made of their own sworn testimonies, Zanoli left the bench for about 20 to 30 minutes, at which time Officer Shea, for some reason, also left the courtroom. A witness that I had taken with me to this circus event surmised that Shea was probably talking with the magistrate behind closed doors about all of the ways he had bungled this case and how he might regain the upper hand during a likely appeal with another corrupt judge of the 52nd District Court. Importantly, when Zanoli returned to the bench, he had only two things to say. First, he quickly cited some Michigan-compiled law number stating that it meant that driving in Michigan is a privilege. Second, he cited another law authorizing him to make a determination of responsibility for the incident occurring within the city limits of Novi, which he decidedly placed upon my shoulders, even though I had proven that I was hit from behind. Again, he also did so, placing me into commerce, without ever informing me beforehand that all of this being carried out informally was actually tying me formally to the laws of commerce and subjecting me to the possible loss, at the discretion of the Secretary of State Ruth Johnson and her agents, of what the state corporation calls a driving privilege. In contrast with my story, however, there is a man by the name of Larry Wise, who has been studying this so-called driving privilege situation a lot longer than I have, and who had some time ago decided to opt out of subjecting himself to this type of corporate corruption and state terrorism that I have been outlining. Larry has preferred to rely strictly upon his federally guaranteed right to travel. You see, the difference here is in the terminology and the state corporation's interpretation of that terminology, combined with our lax understanding and habitual use of the word driving, and the state corporation's misuse of that terminology to suit their own insatiable need for power over us, while stealing our hard-earned wealth to support the growing needs of the state corporation to do the same thing to many others. I will have to reserve telling Larry Wise's story for another time, but it shall suffice to state that I dare say that I would much rather be in his shoes fighting criminal charges as a free man exercising his rights to travel, rather than to be tricked, cheated, and subjected to this other form of domestic terrorism by those I am paying to serve and protect my rights as a natural-born American patriot, simply because I have followed the rest of the cattle, or as some say, sheeple of our society, by blindly applying to the state corporation for the privilege of driving, by way of applying for a driver's license, as if it is the state corporation's right to tell me whether or not I have a right to travel wherever I want in this nation, using a consumer product that I have purchased with my own hard-earned money, while even living elsewhere in the nation outside of Michigan. I'm just letting all of you know that my experience, as outlined in this Rico Busters documentary video, has brought me to a crossroad. As my birthday nears in August, the Michigan Secretary of State, instead of responding to my criminal complaint, Ruth Johnson has sent me another annual bill for license plate renewal, presenting me with an ongoing threat that if I should decide to operate my own vehicle on the public roadway, acting in a private capacity as a traveler rather than in a commercial capacity as a driver, with or without the so-called driving privilege that she may revoke from me at will on behalf of the state corporation, then I too may be terrorized in the fashion in which they are going after Larry Wise if I do not pay this Secretary of State's extortion fee, issued without consideration of my financial ability to pay this demand, as well as the outlandish cost of state-mandated insurance, whether I wanted to or not. I suspect that my decision this time around will be different than all of the previous years, knowing what I know now. That people like Shea, Zanoli, Crawford as the so-called state representative, the commissioner doing nothing about my notice of insurance and securities fraud, and the Michigan Attorney General are all part of this chain conspiracy to deprive me of my rights and to commit acts that are, by their own definition, domestic terrorism. And acting under their false claim, acting deceptively by their own interpreted color of law, that what I am doing, right or wrong according to them, is a privilege rather than a right, and treating me as if I am a slave to their treasonous acts of domestic terrorism. Having shared all of this damned if you do and damned if you don't background on the topic of subscribing to a state license and applying for the privilege of driving, I ask you, the audience, to contemplate your own answers to the following questions that now confront me. What civil and criminal remedies are left for us as a so-called free people when we can prove the criminality of the executive, judicial, and legislative branches of the so-called government corporation, being how they act cohesively rather than by constitutionally required checks and balances, to openly steal our rights and our wealth away from us while ignoring their oath and their job obligations by doing nothing but watching in silence as their peer group of other domestic terrorists get away with the types of things I have displayed so comprehensively here. Is it now time for us to call upon our own administrative remedies of placing common law liens upon these bastards and bitches strategically vying for positions of rule over us, as answers to their negligence in properly affording us rightful civil remedies, even as mandated by their own statutes, codes, and job duties, which they are refusing to follow? Is it now time to pick up a weapon and conduct our own citizens' arrest, which is our common law and statutorily guaranteed right, now that we have full knowledge that what we see and experience are felony crimes of racketeering and treason and other positively identifiable crimes and people committing those crimes? So I ask, what might have happened if any heartsick mother or father of a child or elderly victim of the Flint water crisis had pursued their own civil or criminal remedies in the face of so much stonewalling by the highest offices of the so-called state of Michigan corporations? Suppose they had smacked the lien upon Nick Lyon or Rick Snyder, or suppose they had gone with a gun to arrest any one of those motherfuckers, as is their common law right as well as their statutory right. Do you think the so-called state police or attorney general would have allowed it? So how do you think this story might end for Larry Wise or for me? What are the only options left when our civil and criminal remedies are being applied only against us, or until such point that the powers that be can no longer hide the actual facts of their own terrorism against we the people? Aren't we actually reactionaries to a revolution that was started against us by those municipal and charter corporations posing as government? Again, what choice do we have left to keep America the land of the free?